A single court ruling has just shattered the very foundation of gun control in America. What happened in October isn't just another case, it's a legal earthquake. And the aftershocks are still rattling every state capital in this country. For decades, the Second Amendment has been choked by layers of regulation, red tape, and endless restrictions. But 3 weeks ago, federal judges didn't just trim back a few rules. They obliterated the entire legal framework that has been suffocating gun owners for generations. The anti-gun establishment is panicking, holding emergency meetings, calling special sessions, scrambling to figure out how to contain the damage. Because what the courts just ruled doesn't just tweak the system, it changes the entire game. If you own a firearm, if you carry for protection, or even if you've simply thought about exercising your Second Amendment rights, the 10 new legal realities I'm about to reveal could mean the difference between unprecedented freedom and accidentally becoming a felon overnight. These aren't rumors, these are rulings. They're already reshaping the legal landscape in real time, and if you don't know them, you're already behind. Let's break it down, starting with rule number 10. Rule number 10 detonated like a legal nuclear bomb in every restrictive state house. For years, gun owners traveling across state lines have lived in fear. Even if your firearm was perfectly legal in your home state, the moment you crossed a border, you risked being turned into a criminal. A routine road trip could end in handcuffs. Not anymore. The Second Circuit just established what legal experts are calling the Federal Travel Supremacy Doctrine. This doctrine wipes out state authority to criminalize interstate firearm transport. In plain English, if you're traveling between two states where your firearm possession is legal, you now enjoy absolute federal protection. That protection overrides every single state and local restriction along your route. But here's the truly revolutionary part. The court didn't just protect basic transport. They extended protection to loaded carry during travel stops. That means if you're driving from Florida to Maine with a valid carry permit, you can now legally carry your loaded firearm during gas stops, restaurant visits, or hotel stays. No matter what the local laws say, police departments are scrambling to retrain officers because detaining travelers under old laws is now a violation of federal civil rights. The key phrase gun owners are already memorizing: Officer, I am engaged in lawful interstate travel under federal supremacy doctrine, which provides me absolute federal protection. Rule number 9 transformed private property into a constitutional fortress. The Fourth Circuit demolished the ATF's authority to conduct warrantless searches based solely on gun ownership or firearm-related business activities. For years, home-based dealers, collectors, and even private landowners lived under the shadow of unannounced compliance checks. Those days are over. The ruling is crystal clear. Your home, your land, and your business premises now enjoy enhanced constitutional protection when firearms are involved. Federal agents cannot simply walk onto your property. They now require specific criminal probable cause and a properly issued warrant. Gun ownership is no longer treated as suspicious by default. This has flipped decades of enforcement upside down. Surprise ATF compliance checks that once terrorized lawful owners, gone. Property owners now have a bulletproof response. You need a warrant based on specific criminal probable cause to enter my property for any firearm-related purpose. Dealers, collectors, and ranges across the country are celebrating. For the first time in decades, their doors are closed to federal intrusion unless there's actual evidence of crime. Rule number 8. If firearms are protected, can the government choke your rights by restricting the ammunition? The DC Circuit just answered with a resounding no. Rule number 8 obliterated every ammunition restriction nationwide. The court declared that the Second Amendment's protection of arms explicitly includes ammunition. They ruled that a firearm without ammunition is nothing but a useless club, and therefore, restrictions on ammunition are subject to the same strict scrutiny as firearm restrictions themselves. The historical record was undeniable. The founders never separated the two. This means California's background checks for ammunition are dead. New York's online ammunition bans, unconstitutional. Illinois's serialized ammo proposals, impossible. Connecticut's purchase limits, struck down. Gun stores that were forced to run checks on every box of bullets are now free to sell over the counter again. Online retailers blocked from shipping to restrictive states can now ship nationwide. The ammunition shortage manufactured by bureaucrats just collapsed under constitutional law. Your response if challenged? Ammunition receives full Second Amendment protection, and any restriction that wouldn't apply to the firearm itself is unconstitutional. Rule number 7 shook the ATF to its core. For years, gun dealers lived under constant harassment. Arbitrary inspections, paperwork traps, and license revocations destroyed small businesses across the nation. But the Fifth Circuit just blew the system wide open. The court ruled that the ATF cannot use vague standards or subjective enforcement to deny, revoke, or harass firearms license holders. Gun businesses are now recognized as legitimate commerce protected under the Constitution. No different than any other trade, inspections designed to catch clerical mistakes no longer justify revoking licenses. Home-based dealers, once crushed by zoning complaints, now enjoy federal protection. The ruling even capped processing times. New FFL licenses must be approved or denied within 60 days, and the ATF must provide specific criminal justification for any denial. Dealers now have a shield. Their new phrase, "My operations are constitutionally protected commerce and cannot be subjected to arbitrary enforcement." Rule number 6. The Ninth Circuit dropped a digital sledgehammer on surveillance programs. For years, the government tracked gun owners through phone data, internet searches, credit card transactions, and social media monitoring. Rule number 6 ends that. The court ruled that combining digital surveillance with Second Amendment activity violates the Fourth Amendment, creating what they called an impenetrable digital fortress around gun-related behavior. Tracking your trips to gun stores? Illegal. Monitoring your ammo purchases online? Unconstitutional. Recording your firearm searches or scanning your social media posts for gun content now requires a specific warrant. Your response is simple. I do not consent to any digital searches of my devices or records. Any surveillance based on lawful firearm ownership violates the Ninth Circuit ruling. States maintaining gun registries must now prove they're not feeding data into surveillance programs or risk seeing their registries collapse entirely. Rule number 5 was nothing short of explosive. In a 6-3 decision, the Supreme Court declared that restrictive carry laws are dead. The court ruled that the Second Amendment knows no geographic limitations, and a right delayed is a right denied. 3 bombshell principles followed. First, any permit system taking longer than 30 days is presumptively unconstitutional. Second, good cause requirements are gone completely. Third, states cannot charge more than $50 for a carry permit. Overnight, 12 states must rewrite their laws. This ruling eviscerates decades of arbitrary denials, delays, and fees. Applications languishing for months are now considered automatically approved after 30 days. The magic words? Under the new Supreme Court precedent, my right to carry cannot be subjected to arbitrary delays, subjective standards, or prohibitive fees. Perhaps no ruling terrified the federal government more than rule number 4. The D.C. Circuit ordered the destruction of millions of digitized gun owner records within 90 days, declaring searchable registries unconstitutional. Congress had explicitly outlawed a federal registry when passing the Firearm Owners Protection Act, yet the ATF quietly maintained databases under different names. The court called this what it was: illegal. Even more devastating, the ruling banned states from sharing registry information with federal agencies. They must either keep registries purely local or destroy them entirely. Federal prosecutors are already preparing cases against non-compliant states. Gun owners now have a weaponized response. Any attempt to record my information in a searchable federal system violates federal law and court order. Rule number 3 was described by constitutional scholars as a tactical nuclear strike against red flag laws. In a 7-2 decision, the Supreme Court ruled that firearms cannot be seized without a criminal conviction. Civil asset forfeiture and temporary confiscations are now unconstitutional. The principle is simple: no arrest, no charges, no seizure. Police can no longer say, "We'll hold your guns while we investigate." Red flag orders issued without charges are invalid. The criminal conviction requirement now stands between law-abiding citizens and state confiscation. If officers attempt seizure without cause, your words are clear. The Supreme Court prohibits firearm seizure without arrest and criminal charges. Any attempt otherwise violates the Second and Fourth Amendments. Rule number 2 reversed decades of legal immunity for police officers. The Eighth Circuit eliminated qualified immunity for gun rights violations. This means when officers violate Second Amendment rights, they are personally liable. Departments can no longer shield officers with taxpayer money. Civil lawsuits hit their personal bank accounts. Officers face federal prosecution, lose their law enforcement careers, and are permanently branded as constitutional violators. Insurance companies are already pulling coverage. The doctrine is called the doctrine. If an average citizen knows the act is unconstitutional, officers are presumed to know it too. The phrase that matters? Officer, under the new 8th Circuit ruling, you face personal liability for violating my Second Amendment rights. Qualified immunity does not apply. Finally, we arrive at rule number 1, the most consequential victory in the history of the Second Amendment. In a landmark 6-3 ruling, the Supreme Court declared that requiring permits or licenses to carry firearms is unconstitutional. The Chief Justice wrote, "The right to keep and bear arms is not a privilege to be licensed by the state, but a fundamental constitutional guarantee." This permit abolition doctrine makes one truth unavoidable. If you can legally own a firearm, you have the automatic right to carry it for self-defense. No permission slips required. States can still bar criminals or prohibited persons, but law-abiding citizens are free. 25 states are already dismantling their permit systems. Prosecutors are dropping charges against thousands of people accused of carrying without a license. The constitutional revolution has arrived. These rulings are not just victories, they are the full restoration of freedoms that should never have been lost. For the first time in modern history, the Second Amendment is treated as what it always was meant to be, a full, unshakable right. But here's the catch: rights only matter if you know how to use them. That's why you need to stay informed, because the difference between freedom and felony charges now comes down to knowledge. So if you're serious about protecting yourself, your family, and your constitutional rights, hit that subscribe button to Bulletbound right now and turn on notifications.